NIOS welcomes you in this educational video for subject Political Science, Code 317, Senior Secondary Level, Lesson 12. Name of the lesson is Supreme Court of India. This video is Part 2. Guardian of the Constitution. The Constitution of India is the supreme law of the land, and the Supreme Court is its interpreter and guardian. It does not allow the executives or the parliament to violate any provisions of the Constitution. It can also review any action of the government which allegedly violates any provision of the fundamental rights. This power of the Supreme Court is called judicial review. If it finds violation of any provision of the Constitution, it may declare the concerned law as ultra vires or null and void. It is on the basis of this power of judicial review of the Supreme Court that it is called guardian of the Constitution. It is also called a champion of liberties and a watchdog of democracy. Role and the functions of the Supreme Court. The Supreme Court has a concurrent right with the High Courts to issue directions, orders and writs for enforcement of fundamental rights. These are in the nature of the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. We will understand all these five in further detail. These writs make the Supreme Court a protector and guarantor of fundamental rights. The idea is that in case of violation of a law or right, the court may issue directions for compliance with the Constitution. Thus, the citizens of India are secure as far as fundamental rights are concerned. The Supreme Court has a right to declare a law passed by the legislature null and void if it encroaches upon our fundamental rights. It has rejected many legislations which violated fundamental rights. This shows how the Supreme Court has always served as the guardian of fundamental rights. Let us now understand writs. It is an order issued to a lower court or a functionary of the state to take steps to restore rights of the people. Review of its own judgment. If the Supreme Court discovers that there are some new facts or evidences, or if it is satisfied that some mistake or error took place in its previous decisions, it has the power to review the case and alter its previous decisions. This is generally done when a review petition is filed. Normally, review is done by a bigger bench than the one that originally decided the case. Judicial review. It is a process through which judiciary examines whether a law enacted by a legislature or an action of the executive is in accordance with the Constitution or not. The power of the judicial review was first acquired by the Supreme Court of the United States. Now it is freely exercised by the Supreme Court of India and in many other countries. Our high courts also exercise this power. Judicial review does not mean that every law passed by the legislature is taken up by the Supreme Court for review. It only means that the court will review the law as and when it gets an opportunity. This is possible in two ways. First, the court can review the law if its validity is challenged. The Supreme Court or High Court may get an opportunity to review a law in another situation also. If a person or institution feels that his or her rights are violated or a certain benefit due to him under a law is being denied, the court, while examining such a petition, may come to the conclusion that the law under which relief is sought is itself unconstitutional, therefore relief may not be granted. In a democratic country like India, the power of judicial review is an important guarantee of the rights of the people. Besides, the Supreme Court has been interpreting various provisions of the Constitution. Its rulings are treated as law of the land. Supreme Court as a custodian of fundamental rights. Supreme Court plays its role as a custodian of the civil liberties and in particular of the fundamental rights. The right to equality is an important right which ensures equality before law. The right to equality also means absence of special privileges and inequality of treatment. So the Supreme Court is the name of protective discrimination, has justified the benefits or concessions in the form of reservations or relaxation of eligibility conditions. The right to freedom has given various kinds of freedoms to us, to all of us. But the freedom of press was not mentioned in the Constitution. It was decided by the Supreme Court that freedom of press as a right is implied in right to freedom of expression. Thus, the court expanded the right to freedom. Let us have a break here.
प्रकाशित करने, राहों को आलोकित करने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। जीवन ये प्रकाशित करने, राहों को आलोकित करने।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो। धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का द्वार खुला सबकी खातिर। शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बात,
कोई मन चाहा केंद्र चुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने।
Let us continue after the break. The Supreme Court has regarded the right to know as an important right to be able to take part in the participatory process of development and democracy. So it is an important right, which is right to know, so that all can take part in any process of our country's development. And the court had ruled that right to life in Article 21, which implies and includes the right to education and clean environment also. If we talk about regarding the delay, in deciding the cases, the Supreme Court has held that delay in trial constitutes denial of justice. It has also laid down that speedy trial, releases on bail of under trials, free legal aid to the poor and accused are also the fundamental rights. The Supreme Court has used its power of judicial review and given various historic decisions to safeguard the rights of the individuals. It has stood guard of linguistic rights of minorities, religious rights of the people, welfare of the workers and daily wage earners. If also has taken action to protect bonded labor, prevent exploitation of women, children and deprived sections of society. The power of judicial review is an important guarantee of the rights of the people. It does not allow any violation of the Constitution. It has given several new interpretations to the constitutional provisions. Thus, it has protected as well as expanded the Constitution. Judicial review. Supreme Court, through its power of judicial review, has guarded our rights in various walks of life. The Supreme Court has given momentous decision through what is called judicial activism. Supreme Court take up case related to environmental concern like closing of factories in Agra to protect Taj Mahal. Judicial review. The court has given such rulings as compulsory use of CNG fuel for the use of public transport vehicles in Delhi so that pollution could be brought under control. Similarly, for the protection of lives of people, it has made the use of helmets compulsory for two-wheelers users and even the pillion riders. public interest litigation. The judiciary, including Supreme Court, entertained litigation only from those parties that were affected directly or indirectly by it. People of Delhi filed PIL for protection of environment, which brought up the use of CNG run vehicles. It heard and decided cases only under its original and appellate jurisdiction. But subsequently, the court permitted cases on the ground structure of government of public interest litigation. It means that even people who are not directly involved in the case may bring to the notice of the court matters of public interest. It is the privilege of the court to entertain the application of public interest litigation. The concept of PIL was introduced by Justice P. N. Bhagwati. PIL is important because justice is now easily available to the poor and the weaker section of the society. The Supreme Court, on the basis of letters received from journalists, lawyers, and social workers, and even on the basis of newspaper reports, has taken up a number of matters of public interest. Under PIL, the rights of under trials held under illegal detention have been restored. The Supreme Court ordered the release of many detainees without trial on the ground of their personal liberty, which could not be curbed due to judicial or bureaucratic inefficiency. The Supreme Court has also taken up steps to free bonded laborers, tribals, slum dwellers, women in rescue homes, children in juvenile homes, and child labor, etc. Let us take a break here.
करने राहों को अलोकित करने,
जीवन ये प्रकाशित करने राहों को आलोकित करने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। जीवन ये प्रकाशित करने राहों को आलोकित करने।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो,
धन साधन समय की सीमा से विद्यालय जो मुक्त हो। कभी पढ़े हम कहीं पढ़े वे विषय के लोट से युक्त हो। कभी पढ़े हम कहीं पढ़े वे विषय की लोट से युक्त हो। मित्रों हम उठे और जागे, मंजिल आने की ध्वनि सुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। जीवन ये प्रकाशित करने राहों को आलोकित करने। राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बात कोई मन चाहा केंद्र चुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने।
Let us continue after the break. In case of environmental pollutions, the Supreme Court has ordered closure of a few factories near Kanpur, Delhi and other places. So this was the Supreme Court's initiation because of environmental pollution, that it was ordered that all the factories which are causing pollution, they should be closed. With more and more decisions coming from the Supreme Court, the scope of PIL has widened. Now a person can approach the court through a letter. And if the Supreme Court believes that the matter is of public interest, it can consider the letter to be a petition and direct the hearing of the matter so that public interest may be protected. The process of PIL has led to increased judicial activism. We have understood the lesson so far. Now there are some exercise questions. I hope you will be able to answer the answers. You will be able to answer all these. This is fill in the blank. The judges of the Supreme Court are appointed by the dash. You have to choose one option out of the given options. See the answer. President is the answer. The judges of the Supreme Court are appointed by the President. The second fill in the blank. The judges of the Supreme Court retire at the age of dash. So what is the age of retirement? There are three options. Is it 60? Is it 62? Is it 65? So the answer is 65. The judges of the Supreme Court retire at the age of 65. This question, the dispute between two or more states is brought before the Supreme Court under it dash jurisdiction. Three options are available. Original, appellate or advisory. So original is the right answer. The dispute between two or more states is brought before the Supreme Court under its original jurisdiction. The Supreme Court is dash to give advice to the President of India. Bound and not bound. So the answer is not bound. Supreme Court is not bound to give advice to the President of India. These are two more questions. What is judicial review? And next question is, what does PIL mean? We have already discussed the answer in our video. So you can go through the video again and discuss with your friends to find out the answer. So this is for your self-practice. So we have understood the lesson and discussed the answer. Thank you.